People v. Smith.
May it please the court, Stephanie Stair for Mr. Smith. May I please reserve 2 minutes for rebuttal?
Yes.
It is uncontroverted that the object used in Mr. Smith's case was a BB gun.
Can I ask you, just to frame out this issue for us, are you arguing that because it was a BB gun, you should have gotten the affirmative defense, or are you arguing because it was a BB gun, there should have been a reduction to the Rob 2?
I'm saying a little bit of both. Because it's a BB gun, he was entitled to the affirmative defense because it's not a firearm, but it really should have been charged as a Rob 2 to begin with.
Okay, so if we go with the first option, if it was that you're entitled to the affirmative defense, is it treated like every other affirmative defense, or do you think you automatically get it if you know that the weapon was a BB gun?
Our position is if you know the weapon is a BB gun, you automatically get it, almost as a matter of law. My reading of the statute...
Okay, but is that contrary to how we view affirmative defenses, which say you have to give a view of the evidence that supports the defense?
Right. So I think what that comes down to is the affirmative defense language in subdivision 4 only refers to firearms. If you look at it, it says such pistol, revolver, etc. It does not say such object that was displayed. So it's a condition precedent to that operability analysis that the item was in fact a firearm.
Right, so the people, I think, are saying because a BB gun is not a firearm, then this doesn't apply at all.
I think this was charged wrong. In Mr. Smith's case, it was absolutely charged wrong.
So you're
They knew it was a
asking
BB
us
gun.
essentially to make a per se rule that any BB gun is not a firearm capable of, whatever the language is, causing serious bodily injury or death.
Because it's not a firearm. So there's subdivision 2 and 3, that if you want to go the path of causing injury.
Because it seems to me, to follow up on what Judge Singas was asking, and there's 3 ways you could do this. You could say, I think the Fourth Department's rule, which is yes, it is, and you have to show this particular weapon was not. A BB gun is a firearm capable. Or you could say, I think, which you're kind of saying, you could say maybe, depending on the BB gun, or you could say no, any BB gun is not. And which of those 3 are you asking for? Yes, maybe, or no?
I am asking that the affirmative defense, the burden on the defense to get the affirmative defense is met either by showing it's not a firearm, which a BB gun is not a firearm.
So BB gun per se, not a firearm capable.
Correct.
You were about to say or, I think. You were starting to count on your
Or
fingers.
if it's an unknown object, then they have to show that it was not a firearm capable of producing,
So
et cetera, et cetera.
if you show in the course of this trial that that you raise enough evidence to get the affirmative defense of it was a BB gun, then it goes to the jury and all they have to decide is, was it a BB gun or not?
Yes. And again, that goes back to how this was charged wrong. So there's
Well,
a burden on...
Could a BB gun be an other weapon, not firearm? Because I think it's not a firearm, right? It doesn't use an explosive.
Correct.
Could it be an other weapon capable of causing death or serious injury?
That would be properly charged under subdivision 2 or 3.
Well, doesn't 4 read allow for that or not?
Not in my reading, Your Honor. Because it says such pistol doesn't, excuse me, I'm going to start all over. Because it says such pistol is not a loaded weapon, et cetera, and not such object that is displayed as a pistol, I read that as it has to be a firearm first before you get to that
What do you
operability.
think in the statutory text the such is modifying? What's part of what comes before is such related to?
Pistol, revolver, firearm.
Well, in the statute, it's what appears to be a pistol, revolver, firearm.
Right. So there's 2 things I want to point you to. The CJI instruction takes out that such language entirely. The jury instruction, if it were given, literally just says the pistol, revolver, et cetera, was not a loaded weapon from which...
We're focusing on the statute.
Yes,
It is what the statute says.
correct, correct.
So your interpretation of 4 is that what appears to be cannot encompass something that is not any of these items, but merely appears to be?
Correct.
So what meaning then do the words appears to be have?
So that goes to the legislative intent in subdivision 4. It It balanced, and this court
I'm
goes through that
familiar
in
with the
Baskerville.
history of the provision, but you're saying we should read those words consistent with the legislative history and not just sort of take the words for what they mean, which could, I think, possibly include a BB gun, yes?
It does and it doesn't. So the language of robbery second sub 2B is identical to robbery first sub 4, except for that affirmative defense.
But
So
why
that's where the
wouldn't you look at the specific text? It says displays what appears to be. Are you saying we just totally disregard it, even though that language is clearly there, and look towards legislative intent instead?
look at legislative intent, but also look at this
But
court's
why? If the language is clearly there, what's ambiguous about what appears to be?
Because what appears to be is not repeated after the word such. And this court in Baskerville and Lopez makes it very clear, and I will quote Baskerville, "It's an affirmative defense that the object displayed was not an operable firearm." This court used the word
You're saying
firearm.
because the statute doesn't say such apparent pistol or revolver, that renders it ambiguous? To the extent that we have to now go back and look at what the legislature intended?
Yes.
And you
But
just
we
read-
also said,
You just read was not an operable firearm, right? But a BB gun is not an operable firearm, and don't we have cases where people have their hand in a hoodie or some
Yes.
other, and we allow the affirmative defense under 4, no?
So that was the "or" that I said earlier, when it's an unknown object, right? You have
But
those,
the unknown object isn't in this statute.
right,
I
I'm
mean,
looking,
if you read such to restrict it to firearms, then it seems to me your interpretation restricts the defense to things that are firearms. Actual firearms, not what appears to be.
I'm restricting the defense's burden of proving it's an operability, which is what the court in this case concentrated on, the trial court. I'm restricting that to firearms.
Maybe I'm confused, but it sounds to me like you are proposing a narrower rather than a broader reading of the affirmative defense.
It's a narrower applicability to what the defense has to prove. In my view of it,
I'm not sure I follow that. Maybe you could explain it.
that's fine. If it's not a firearm, and a BB gun is not a firearm, I think that in and of itself shows that if the DA decided to charge it under this subsection, the affirmative defense has to be
That's a distinct
read.
argument, I think, right? I mean, I took you in your brief to be arguing that the affirmative defense should have been given, not that there couldn't be a charge brought under subsection 4. Those, I think, are different arguments. And now I think I hear you saying that you can't charge under subsection 4 for a BB gun. Maybe I'm mistaken.
I think going forward, the appropriate thing to do is not to charge under sub 4.
But I don't think you raised that argument to us. And I thought you focused on the affirmative defense.
I did, in the brief, yeah.
can I just
Yeah,
have
of
one
course.
more
Yeah.
question? So you started an answer regarding the same language in the Rob 1 and the Rob 2, exact same language, right? So what do you think the significance of that is?
So the legislative intent needed to balance the prosecution's difficulty with proving an unknown object, an object that they never recover, against the defendant's ability to show that it wasn't an operable firearm. So a lot of the cases are, finger in the pocket that we talked about, or metal bar wrapped up, a gun is never recovered. Or there's cases where there's a BB gun, but also a second unknown weapon.
Well, can I ask you another question? And I don't know if you know the answer to it, I'll ask the people as well. In terms of operability in your jurisdiction or in your department, do the BB guns get tested by ballistics for operability?
They do not, as far as I know.
Thank you.
Good afternoon. May it please the court. Amy Wallensack on behalf of the people. It's our position that in this case, defendant didn't meet his burden of proving the entitlement to the court charging the jury on the affirmative defense to robbery in the first degree.
Okay, and what kind of evidence would he have to put forward? Do you know if ballistics tests for operability of BB guns?
I personally don't. I've never spent any time in the Special Investigations Bureau, candidly, so I really can't speak to that. But I do think, I have to imagine that there is somebody that could have test-fired this particular weapon that was recovered from the defendant's apartment and said whether or not it fired anything or worked or discharged a shot.
Well, is it your position that every type of loaded operable BB gun is capable of producing death or serious injury?
I think it could.
Yeah, necessarily as a matter of law. Because it seems otherwise, there may be a difference between the Fourth Department's position and some of the other appellate division departments in that you may be able to prove that even though this is an operable loaded BB gun, this particular BB gun is not capable of producing death or serious injury. And it seems to me the trial court and the appellate division read the defense as restricted to operability and loaded, and not simply that it's a BB gun, but it's a small BB gun.
If I am understanding your question correctly, Your Honor, and please correct me if I'm not, my understanding, or how I read the Fourth Department's decision and how I read the statute as well, and I think getting back to this when the affirmative defense and also the statutory burdens, this particular subdivision of robbery in the first degree was meant by the legislature to address an issue of evidence when the weapon's not immediately recovered after the robbery. So I believe it was this court's decision in Baskerville. There was a toothbrush.
Sorry, immediately recovered or just recovered?
I get recovered at all, but I would note in a lot of the decisions where this applies, I think there's a bit closer temporal proximity to the apprehension of the defendant. So in Baskerville, I believe it was a subway platform robbery. If I'm misremembering the case name, I apologize, but the defendant was followed by the police and then he was apprehended, and when they searched him incident to arrest, the only object he had was a toothbrush. And there was no firearm that was recovered in his path of flight. So we know in that case the toothbrush was what was used. Here there was almost 2 months, I believe, between the robbery and the search
Right,
warrant.
but the people's theory is this was the BB gun. No?
It's very likely that it was, but none of the victims were able to identify it as the weapon.
I thought that was the argument at closing.
I would note
Did I
that.
misunderstand the record?
No, I do know that the prosecutor argued that it's very likely that this was the BB gun, but I would note that her summation isn't evidence. It would be about an inference to be drawn from there. I don't think we were able to prove the weapon that was used because none of the victims were able to identify it, and there was that gap in time, like I said.
If a
between-
defendant is entitled to the charge, how does that come about?
So with
How
this,
does the burden process work?
so in this particular case, because we charged it under subdivision 4, the people had to prove that the defendant displayed what appeared to be a pistol, revolver, rifle, shotgun, or other firearm in this particular case. And we did that here because all of the victims testified that when the robber came into the hair salon, he displayed something that appeared to be
Did you have to prove operability?
No, we didn't, Your Honor, because again, the legislature in enacting subdivision 4 in the robbery in the first degree statute, I believe this court talked about in several of its cases, I think Lopez and Gilliard, they were intending to solve the problem that the people often find themselves in when no weapon is recovered. We can't exactly prove whether it was loaded or operable at the time of the robbery if we never recover it.
So if I understand you correctly, you read subdivision 4, the affirmative defense there is applying to things that are not firearms, but appear to be firearms.
Yes, and I believe in Gilliard and Lopez, this court, in describing that, because the affirmative defense only applies when subdivision 4 is charged, this court seemed to interpret the such, referring back to that first phrase, what appears to be a pistol, revolver, or other firearm.
I don't think so. In Gilliard, we said such object, and if it's an object, you get the affirmative defense.
Well, this court, so there's the first part of subdivision 4 that says a defendant commits robbery in the first degree when you display what appears to be. And then there's the affirmative defense that comes in when such pistol, revolver, other firearm is not actually a loaded weapon capable of discharging a shot. And as I read this
So
court's...
you think you don't get the defense for a finger in the pocket?
You would if there's evidence that it's a finger in the pocket and not a loaded weapon from which a shot can be discharged that's capable of causing death or serious physical injury.
Regardless if it appears, because of the way it's masked, to be a, let's take one of them, pistol?
So if it appear, so I kind of view it as we have to meet our burden on the first part of the statute, and then it's the defendant's burden on the second part. So we have to show that he
So
initially.
does that play into whether there's a reasonable view of the evidence to support that charge being given?
I think so, if I'm understanding your question correctly. Judge
In
Sherman.
order to get the charge, are you saying there must be a reasonable view of the evidence to support that in the case of a finger, it was a finger?
Yes, I am, Judge Troutman. And here, there was no reasonable view of the evidence that the object that that the defendant displayed during the robbery was not a loaded weapon from which a shot could be discharged. There was no testimony or
Well, but
evidence
that-
about.
but that isn't a requirement, is it?
It is. The object that was displayed
It
during the
has to
robbery.
also be what the item also has to be capable of producing death or other serious physical injury, right?
Yes. And so I suppose applying the statute to this case, we met our burden on proving what we had to in that first part of the statute, because all of the victims testified that he displayed what they perceived to be a real gun.
Right.
And then in order to get the affirmative defense, defendant could have taken the stand and said that this this weapon that I had, it was not capable of causing death or serious physical injury. It was unloaded, it was inoperable.
Right, but the court seemed to limit the defendant to showing it was either inoperable or not loaded. Not that it was a loaded operable BB gun, but a BB gun not capable of producing death, and thought it was constrained by a Fourth Department opinion, whose name is a little difficult to pronounce, but starts with an A.
Yeah, the Akinlawan, I think I'm pronouncing correct, or close enough.
Yep.
Yes, so as I read the Akinlawan, that's kind of what I'm getting at, is that the
That's out
defendant.
of step with some other appellate division decisions.
It's in step, I believe, with the Third Department and the First Department. I believe the First Department in Padua follows a similar analysis, and the Third Department, I believe it was, I cited to both cases in my brief.
Yeah, but why
refer-
isn't the second department correct to say that, you know what, this is not a firearm, and the legislature made a conscious decision to have two subsections, one a B violent, one a C violent, that say the exact same thing? Why doesn't it make sense the way the second department views it, that if it's a BB gun, it's not a firearm, and then you get knocked down to the C violent, and then everything displays what appears to be, comes into effect? Why is that?
Well, I think it's because of the language that is used in the affirmative defense. The legis-
Both, the language is exactly the same.
Well, again, I don't think it is in the affirmative defense. With the affirmative defense, again, the defendant had to show that the object displayed was not a loaded weapon from which that shot could be discharged. The legislature certainly could have said that it's an affirmative defense when the object displayed was not a firearm. They didn't say firearm, they said a loaded weapon from which a shot capable of causing death or serious physical injury could be discharged. And I note, too, when the legislature talks about firearms in Article 268 of the Penal Law, there's always this reference to expelling a projectile by way of explosive. I believe it's Section 265.00, Subdivision 15. When they talk about a loaded firearm, they mention one that is loaded with ammunition. And again, that dischargement by way of an explosive. There are certain terms associated with firearms that just weren't used in this affirmative defense. Again, it was limited to a loaded weapon that discharges a shot capable of causing death or other serious physical injury.
Are there operable BB guns that are not capable of producing death or other serious physical injury?
I believe so. I referenced the court to some articles about BB guns in my brief. So the one that was recovered from the defendant's apartment in this case was a CO2 air pistol. So it discharges the BBs through the use of these cartridges that contain compressed gas. And these ones are readily capable of causing death. I know in
But
Saratoga.
there is some
There are
type of
some.
BB gun that would not.
Yes, I think the easiest one to kind of envision is there used to be like the plastic ones that had the orange tip on the end, and that orange tip was how you could easily recognize that it was a BB gun. My understanding is most of those expelled their BBs through the use of a spring-loaded contraption, kind of like the one in A Christmas Story with Ralphie's BB gun for Christmas. And
But even that one
No,
could
that's
put
a-
your eye
that's a-
out.
No, I'm
You could
sorry,
shoot
that's a pump-action compressed air. It's not a spring-loaded.
my apologies if I
I know
erred
that
on
musical
the.
pretty well.
But,
Gotcha.
so, but
It's a Red
why
Ryder.
isn't, I'm sorry, why isn't that capable of producing death or other serious physical injury if
Well, I
you
guess-
shoot towards someone's eyeball?
I think there are a lot of them that is,
Then I'm talking about the one
Ones
that
that
you
aren't.
started out saying, well, there's this one that wouldn't fit this category.
I think there's ones that are much more similar to a toy, really. And again, like, I think any of them probably could if, say a
Do we read-
4-year-old
what-
took.
Don't we read something into readily capable?
And I think there are a lot of BB guns that are readily capable. Like I said, there are the CO2 air pistols that are commonly being produced today, and those are the ones that are primarily in the marketplace. And those ones, again, do readily cause death. There
But you
was
seem to
a-
be acknowledging that not all
No,
are
and again,
readily
I,
capable of causing serious injury or death.
no, and I think that again goes into the affirmative defense. It's on the
And
defendant to
so
prove.
if there was a reasonable view of the evidence because of that which was presented, that it wasn't capable of causing the injury or death, then they would be entitled to it.
Yes, I agree. But if there is,
But your argument is they don't automatically get it just because it's a BB gun.
no, they don't. They have to put in the work of showing that, as the statute says, that it was unloaded, inoperable, or not capable of causing death. Again, I would draw the court's attention, there was a case.
Because it fits the first sentence, it appears to be one of those things?
So if it
Not
appears,
because it is.
yes, that is what we have, that is what the people have to prove in order to establish robbery in the first degree under this subdivision. And then it's the defendant's burden to prove the affirmative defense by a preponderance of the evidence. And if he doesn't do the work to show the entitlement to the affirmative defense, it's not charged to the
So,
jury.
so if you use something, let's take a screwdriver for one moment, but it appeared in the way it was masked
Yes.
to be one of the listed types of firearms. A screwdriver used appropriately or perhaps aggressively might cause serious physical injury, no?
But it's not a loaded weapon that discharges a shot.
It's
So in
not
that,
capable of making a shot, right?
no, it's not. It's a screwdriver. It doesn't discharge a
So it
shot.
would fail on one of the other little.
Yes, and the affirmative defense would apply for the screwdriver because, again, it's not a loaded weapon. And if the court has no further questions, I would ask it to affirm the conviction in this matter. Thank you.
Thank you.
So in
So are
referring,
there BB guns that are not able to produce death or other serious physical injury?
I think most BB guns are not capable of causing death or
Was the
serious
one involved here the type that was not readily capable of doing
In
that?
our opinion, yes.
Because?
Well, it was never fired. It was never test fired. It was never,
But what evidence was offered to show it wasn't capable of causing death or serious physical injury?
I don't know that there was evidence presented on
Is
that.
that your
but
burden to show that?
Our reading of it is that the burden of getting to operability is
Okay.
you first have to show that it's a firearm. So we never should have gotten there. And this court, during my opposing counsel's argument, Akinlawan is not in step with the other departments. Akinlawan, prior to Akinlawan, even the fourth department agreed that a BB gun is not a firearm.
So you want us to say this is not a firearm, so it's a failure of proof on the main case, not an affirmative defense issue?
There are cases where they charge it as the Rob 1 Subdivision 4, but the affirmative defense is given because it's a BB gun and not a firearm.
And that's the
And-
wrong way to do it. You're saying it should never be charged as Rob 1.
Yes, in a perfect world, I think this shouldn't have even got past grand jury review.
Because we should excise what appears from subsection 4.
No, in a perfect world, a dumbed-down, rewritten...
No, the statute.
Right.
Forget the perfect world, the statute.
Which may be that.
Just
definitely
the
not perfect.
statute.
A different version of the statute, in my opinion, should read,
Yeah, but
displays...
this, okay, but
of this
this
statute.
particular, the one that
Yes.
he's convicted of, let's
Yes.
go with that.
displays what appears to be a firearm instead of that
And you
list.
would have us excise those two words.
The such as?
No,
What
what appears.
appears.
No, I think...
Actually, what appears to be, excuse me,
I
it's
would
more than
like
two.
the list of things to be substituted firearm. So displays what appears to be a firearm, except that it is an affirmative defense that the object either wasn't a firearm or was an inoperable and unloaded firearm. That's like my dumbed-down rewriting of what the
Yeah,
statute
I
should
don't
say.
really
We didn't say
understand it
that.
because it's what appears to be, right?
Going back to the text, I'm sorry, did you want to respond to that?
I was gonna,
I mean, those words suggest that it need not be in fact any of the listed weapons, right?
right, but the linchpin in this case is that we know what the object was. So that's what makes it different from all the other lines of case of where it applies, where it
Well,
doesn't
just
apply.
then follow up, then you disagree with counsel who said it, we don't know that this was the BB gun because it was 2 months later.
We absolutely know that this was the BB gun. It was uncontested by the DA. It was uncontested in the charge conference. They never argued in the charge conference it wasn't the BB gun. The judge never said it wasn't the BB gun. And just very briefly, I know my red light's been on for a while. The Akinlawan case that the trial court relied on, they were going to grant the affirmative defense based on this court's decision in Howard. And then they read Akinlawan. Akinlawan is sort of a detour. It relies upon third department cases, Richard and Perez, under the framework of analyzing if a BB gun is either a deadly weapon under Assault 2 for the Richard case or a dangerous instrument under Rob 1 sub 3 for the Perez case. So in relying on that, they conflated the requirement of showing operability and unloadedness with whether or not it was a firearm. And prior to Akinlawan, the Fourth Department agrees a BB gun's not a firearm. After Akinlawan, they just point to Akinlawan. I think that's what resulted in this erroneous requirement of showing that a BB gun is unloaded or inoperable in these types of
Counsel,
situations.
before you say, I just wanted to go back to one linguistic thing that I noticed in subsection 4. You have that offense part of the language, which talks about what appears to be a pistol, revolver, rifle, shotgun, machine gun, which are all firearms, and that is fire. But then when you go back down to the affirmative defense, we don't see the word firearm, and we don't see a repetition of pistol, revolver, rifle, shotgun, et cetera. What we see is weapon. And that seems to me to pose an additional challenge to your interpretation of what this affirmative defense means. I can try to explain it to you, but I think you probably understand what I'm talking about.
Absolutely. I don't disagree with you. I got lost in the weeds in this so often that I can't even tell you. I think it's a poorly written statute. I think that part of the affirmative defense obviously parrots the language of more in line with dangerous instrument than firearm or anything else. So
But isn't weapon big enough to allow for a BB gun? That's really that's the rub for me.
and I can see that interpretation, but I think because it's tied to the language of operability and serious physical injury and death, that's what.
Isn't the more natural reading that these categories are a subset of weapon, and we're only talking about these categories?
I'm sorry, I don't understand the question.
Well, if it was just about a loaded weapon, they wouldn't have repeated such pistol, revolver, rifle, shotgun, machine gun, or other firearm. These are, right, types of weapons? That's all that means?
They're types of firearms.
But, no, was not a loaded weapon. That's the rest of the, well, that's the next part of the sentence, I shouldn't say the rest.
Right, and again,
The
think-
natural reading of that is weapon is the broader category, these are subclasses of that broad category. Firearm is a broader category too, don't get me wrong, but it's,
Right.
right? It's
Right.
subsumed within the broader category of loaded weapon.
I could see that interpretation, but I think it's
Well, why
very-
shouldn't we see that interpretation?
Because it's very clear that this subsection in this court in Baskerville says it's an operable firearm. You use the words operable firearm in relation to the affirmative defense, not just a loaded weapon, not, Ralphie's shotgun from Christmas morning or, that kind of thing.
But you're saying it's not a firearm, but yet you're entitled to the affirmative defense?
It's a rifle, not a shotgun.
It's a rifle. Terribly sorry.
Concede that, counsel, just concede it.
I say that he's entitled to it because it's not a firearm. So just showing it's not a firearm has satisfied the fact that it's not an operable pistol, revolver, et cetera.
Thank you.